Throughout the history of the United States criminal justice system, in corrections and punishment, we have always had this debate on how should we punish people? How should punishments be determined and set forth? The arguments have gone back and forth between the legislature and judges. The Supreme Court has made some decisions into the matter, but ultimately, sentencing and punishment for deviations of criminal law is left into the hands of the jury. Even part of our Declaration of Independence was a complaint to the Crown in England that we as the people, as a community, did not get to determine how other people or how defendants in our own country were punished for the crimes that they committed in our jurisdictions. For much of the history of the United States and through most of the 20th century, state, district, and federal district court judges had a great deal of discretion to decide the appropriate punishments in criminal cases. And they were sending people to prison for what was known as an indeterminate period of time or an indeterminate sentences. Judges would decide whether to sentence a convicted offender to incarceration or probation and how long and how much time they would spend in prison. What we found was ranges. Okay, even still, the judge didn't have, even though he had the discretion to sentence an individual to prison for X number of years, or as the federal government goes by months, it was ultimately the parole board that decided whether or not to release. And this came about, or what ended up was we saw institutional racism and a lot of institutional racism, which called for sentencing reforms. The liberal reformers argued that prisons had become extremely overcrowded and dangerous places run by violent inmates who brutalized the weaker inmates among them, while corrupt guards and prison officials looked the other way. And a lot of this come about in Ruiz v. Texas. We had the tender system and the key holders where the inmates actually ran the prison and the guards were there to make sure nobody escaped. The conservative critics and politicians complained of a revolving door justice in which suspects were apprehended and released mere hours free to continue preying upon the innocents. People, even if they were sent to prison, they were sent to prison for a period of time and then they got out of prison and then they went right back to criminality. Okay, although both liberal and conservative reformers disagreed on their diagnosis of the problems, they did find common ground in that they believed that discretion had to be removed, or much of the discretion had to be removed, and that there was no legitimate basis for indeterminate sentencing, because indeterminate sentencing would let some people go free and other people not. So what happened was the three things. They concluded that the problems stemmed from excessive discretion, like I'd said. Second, the apparent failure of rehabilitation meant there was no legitimate basis for indeterminate sentencing because nothing worked. We had moved into the nothing works theory and just to the corrective issues. If we can't rehabilitate them, we're just going to incapacitate them and keep them away from society. And third, was that state and federal lawmakers could solve problems by asserting greater control over the process and limiting case level discretion, and by setting up what is known as determinate sentencing. Determinate sentencing was one of the first major reforms that several of the states had adopted. They abolished parole altogether, ending indeterminate sentencing. Okay. The judge's orders were a specific sentence. In other words, the maximum number of months to be placed in prison. Okay, the judge's decisions determined how long someone serves in prison rather than the parole board. Okay, offenders in most of the determinate sentencing states were still able to reduce their time in prison through good behavior called good time. Completing programs, completing rehabilitation added to your good time and allowed you to go free. There also was a limit on judicial discretion by declaring in the law the specific sentence durations and within narrow sentencing ranges. Specifically, for example, in Texas, uh, our criminal code tells you what level of offense it is, and the law states what the appropriate punishment range is, and the judge has to make a decision within that legislative range. The next reform that we found was sentencing guidelines. Sentencing guidelines were first established in the state of Minnesota in 1980, and by the 1990s, all but about 20 states and the federal courts operate under some form of guideline system. Preemptive legal weight, that is, the judge must provide adequate reasons for sentencing people outside of the designated legislative range, or else face a reversal in appeals. All of the sentencing reforms that were enacted, determinate sentencing, presumptive sentencing, the sentencing guidelines, did the most to limit discretion of the judges and the courts, and also within the corrections institutions. But most states did not go that far. In fact, most states continue to use an indeterminate sentencing program. Nearly every state, however, took steps to ensure that certain offenders serve longer terms in prison. One of the most common ways states did this was by passing laws commonly known as mandatory minimums. Mandatory minimums is another reform that we are going to look into. As I've already mentioned, many states have mandatory minimums, and this establishes a mandatory minimum time to be served in prison for specific crimes. They limit judicial discretion in sentencing. They're based on facts about the defendant. The mandatory minimums are triggered by factors such aggravating factors, such as weapons, the quantity of drugs, the type of drugs, the location of the crimes. For example, was it inside school property? Was it in a no drug zone? Was it in a no gun zone? Habitual offenders also face 3-strike laws. The state of Texas has an enhancement program to where if you commit the same offense twice or more than once in any 10-year time span, your punishment is enhanced to the next level. And this could go on. If you start with a second-degree misdemeanor, and it figures out within 10 years you committed the same offense 5 more times, you could be facing a life in prison as a first-degree felony. All of these were in an attempt to take the discretion out of the hands of the judge and the parole board and put them back into the hands of the people, into the legislatures that make the law, and the people that vote for the legislatures, and the people who sit in the jury. As I mentioned in the beginning, juries are a very important part of the history of American jurisprudence. It's also an important part of American history. Juries was one of the complaints listed in the Declaration of Independence when the United States of America sought independence from England. Uh, of the 29 reasons listed, 5 of them had to do with jurisprudence, and juries was one of them. And the Supreme Court has maintained a strong alliance to the decisions made by juries. Whether it was in Apprendi versus New Jersey, uh, Harris versus the United States, Cunningham versus California, they all stated and they agreed, whether it's Justice Scalia writing for the conservatives or Ruth Bader Ginsburg, Justice Ginsburg writing for the liberals, they all agree that enhancements and sentencings outside of the legislative guidelines must be dictated by a jury. A judge himself cannot determine that there are aggravating circumstances to enhance a punishment. That punishment needs to be enhanced by a jury. And if a jury decides to go outside of the legislature, this has been accepted by the courts. Like I said, in Cunningham versus California, the Justice Ginsburg wrote, except for a prior conviction, any fact that increases the penalty for a crime beyond the prescribed statutory maximum must be submitted to a jury and proved beyond a reasonable doubt. The court had also declared that Blakely applies to sentences other than terms of incarceration. According to the Southern Union Company versus the United States, the Sixth Amendment reasoning extends to any factual findings that are necessary to justify an increase in available criminal fines and penalties. The courts have relied upon and have determined that the juries are that which is important to ensure that we have a fair and equitable justice system.